Hey, thanks for tuning in again to Answers with Andrew. This is a short video series that I'm trying to do to take on issues and questions that come up regularly in the areas of law that I practice in, which are estate planning, trust and estate administration, corporate or business law for the closely held business owner, as well as commercial and residential real estate law. The question that I want to take on today is, should I add my son or daughter to my bank accounts? I will often have clients come in, and as a part of the planning that we're doing, at some point they will tell me about the child that they, I kind of jokingly call the chosen child, who they feel the most confident with. They feel like they have a lot of trust for them. They feel sort of like this child is the one that's going to not screw things up when they die and can do no wrong. And so at some point they will say, I went ahead and added Joe or added Sarah or added Susie to all of my bank accounts. Is that okay? Or to my money market account or to my investment accounts. And I will often stop them and say, okay, well, what do you mean by that? What do you mean you've added them? Because there are different levels of adding someone to, per se, a bank account. And so I'd like to just kind of go back to the whiteboard here for a minute. This is always the best way, I think, to learn. But let's start by just doing a little refresher, right? This timeline is an estate plan, right? And the dot in the middle is the date of death. We don't know when we're going to die, but we all know at some point we will die. And so there are certain documents in an estate plan that should protect us while we are still alive. Financial power of attorney, healthcare power of attorney, right? People that are able to make business, financial, or property-related decisions for me that I've named in the document. People that are able to step up and make sure that I'm getting a good standard of healthcare in the event that I'm in a hospital or a nursing home. And then after the date of death, remember, POAs are only good until the date of death, and then they are null and void. So post-death, we've got a whole different set of documents, which typically are a last will and testament, a trust, if we've got a trust, or beneficiary designations on our specific assets, right? So I will talk to clients and I will say, look, how did you add them to your bank account? Did you add them as an owner? Did you give them only check signing authority? Did you make them a pay on death beneficiary? Is it a trust owned account? And if so, are they named as trustee in the document? And I just like to kind of, I draw this picture a lot of times for the clients, and I'll say, look, why would we want to make them an owner pre-death when we could just name them in a financial power of attorney? And a lot of times they'll say, well, I want them to be able to pay bills around the time that I die. And I will nicely and kindly remind clients, hey, there is a possibility, believe it or not, that your child could do something other than what you instructed them to do. I know that's crazy, right? Your kids might not listen to you. That's a joke. But the idea is, let's use the documents that we've got to give them permission slips to do the things that they need to do. Let's not circumvent our estate plan by naming them as an owner if that's not in fact what we want to do. Because then what happens when you die, if they take over a $100,000 money market account and they are supposed to split that with their two siblings, well, now you've got gift tax issues where they have to gift money away over the annual exclusion amount. And so had we just named them a financial POA and then perhaps named them in the appropriate percentage a pay on death beneficiary, we would have accomplished both allowing them to pay bills and giving them access to the funds when you died without necessarily causing them to gift over the annual exclusion amount or giving them the opportunity to cut their brothers or sisters out of their inheritance, if that makes sense. And so I'm always trying to look for the best ways to do things. It's not that there's not other ways to do things. You can name a child as an owner of an account, but there are better ways to do things, utilizing our POAs, and then allowing them to be named as either a beneficiary of a trust or a pay on death beneficiary of the account, or even just giving them check signing authority if we want them to be able to sign checks for us. So I hope that this has been helpful, coming to you here today from my office in downtown Akron, Ohio. Love Akron. As you can see, we've got another beautiful sunny day in Ohio. But this is how I look at adding people to bank accounts. I'm not a big fan of it. I think that we should utilize our POAs, and we should not just add people as an owner loosey-goosey without giving some thought to it, because we can get outcomes later that we did not intend.